Good morning. Happy Tuesday. So, in my chat yesterday, apparently Ehline did a video on Lane Myers. And once again, Ehline is fucking retarded. The guy is dumb. So, his analysis was that essentially Lane Myers, if he gets his injunction against harassment, the civil injunction, appealed and overturned somehow, that is going to have some sort of an effect on the criminal case, the criminal convictions and or the criminal injunction against harassment. And that is the dumbest thing I've ever heard. His justification were just two buzz phrases. He said that if the civil injunction against harassment gets overturned on appeal, that will I think he said something along the lines of terminate the or end the criminal conviction by operation of law and or by legal impossibility. And these are buzz phrases that he threw out with zero understanding of either. Let's start off with operation of law. The best understanding that I have of what he's referring to is where statutes or contracts can terminate by operation of law. In the contract or in the statute, if they put an end date for that statute to be effective or for the contract to be effective, when you reach that end date, the contract or statute terminates by operation of law. Nobody had to do anything. It didn't have to get repealed. It didn't have to, the parties didn't have to meet and renegotiate the contract to terminate it. It just ends by its own terms. It's terminated by operation of law. The civil injunction against harassment being overturned, which I doubt it will be, it may be remanded for the trial judge to make a decision based on civil harassment law, because I think he made it based on criminal harassment law. So it may get remanded to him for that purpose, but I seriously doubt it'll get terminated or set aside. But it still wouldn't. But you notice, like in the termination by operation of law, the termination has to be included in the statute or in the contract. The date it's terminated on or the circumstances under which it's terminated. For example, if you pay me $100, I'll make you 100 widgets, right? Once I make you 100 widgets, that contract is now terminated by operation of law. Because the terms have been completed, there's nothing more for it to do. The trial, the civil injunction against harassment is its own separate thing. Maybe we should get into that for a second. Okay, so you have two different cases. The Court of Appeals, if Lane Myers does all the procedural steps required to get the civil injunction against harassment in front of the Court of Appeals would then have jurisdiction to make decisions about that civil injunction against harassment. The criminal trial, the criminal conviction, and the criminal injunction against harassment is a separate thing. The Court of Appeals won't have jurisdiction over this separate thing. So the Court of Appeals can't make any decisions based on this separate thing. That's issue number one. Issue number two is even though the charges in the criminal case, referenced a injunction that was in place, it is not up for appeal. So even if the injunction gets set aside, this is its own separate package, and it would have to be separately appealed. An issue there is that in the plea deal, Lane Myers agreed that he can't appeal that. So that's done. It's never going to get appealed. It's never going to get in front of a court of appeal and be heard on the merits because he agreed, he waived his right to an appeal. He no longer can give that Court of Appeals jurisdiction to hear an appeal on it because he waived his right to an appeal. He has no right to an appeal. So they're two totally different things. And over in the civil case, nothing in that civil case references the criminal case, and so it cannot, there's no mechanism in there to terminate the judgment in the criminal case. It cannot end by operation of law. There's no mechanism to terminate it by operation of law. That was just a buzzword that he threw out, that he heard somewhere, and it sounded good, and he didn't know what the fuck he was talking about, so he threw it out. The second thing is legal impossibility. Legal impossibility is a defense to attempt, right? So for example, if you're selling what you think is cocaine, but you're actually selling what's in the bag is actually just baby powder. So you're out there slinging these bags of baby powder, you think you're selling cocaine. You are attempting to sell cocaine. You are attempting to deal drugs, which is probably a crime in your state. And it's definitely a federal crime. If the police arrest you, they can't charge you with selling cocaine. They examine the contents of the baggie. There's no cocaine in there. But you say, we can charge him with attempt. He was attempting to sell cocaine. It's a legal impossibility. The bags didn't have cocaine. He didn't have cocaine to sell. So he could say, as a defense, I wasn't attempting to sell cocaine. Even if I had completed the act and actually sold the baggie, I would have only sold baby powder or baking soda. I don't remember what was in the, but you get the idea. If I sold the baggie containing the substance, I could not have ever sold cocaine because there was no cocaine in it. That's opposed to factual impossibility, which is not a defense to attempt. Let's say that you try to steal the baggie because you think it's cocaine. So you attempt to steal the baggie from the dealer and you grab it and the police arrest you for stealing. Maybe that's, well, no, they could because you stole a baggie of not cocaine. So you committed a crime. The guy who was trying to sell the cocaine didn't. They could charge you, even though you're like, well, let me step that back. Because that you would have actually, so that wouldn't be attempt, that would actually be theft. So let's say that you think a guy is selling cocaine and you reach into his pocket when he's not looking to try to steal the baggie of cocaine, but there's no cocaine there. And the police see you doing this and they're like, aha, you were trying to steal his cocaine, or you're trying to steal something from him, right? Let's just say you're trying to steal something from him. You say, but the pocket was empty. It is factually impossible for me to steal something from an empty pocket. Unfortunately, that's not a defense. So you see the distinction. Legal impossibility means that you think you're committing a crime, you're trying to commit a crime, but you're unable to commit the crime because legally the thing that you're doing isn't a crime. So you can't be charged, well, you can be charged with contempt, but that's defense to it. That is a criminal defense to attempt. He is appealing a civil restraining order, so it wouldn't apply there. And you're going to say, aha. But he was convicted for violating this thing. If that thing no longer exists, that's a legal impossibility. No, it's not, for a variety of reasons. First of all, under the statute for the criminal charge, there has to be a restraining order in place, an injunction against harassment in place. He never got the court to agree to stay the injunction against harassment pending appeal. Stay means that the judgment doesn't go into effect until the outcome of the appeal is heard. It wasn't stayed. There was a restraining order in place. In his plea deal, he agreed there was a restraining order in place. He had to. That's part of the colloquy that he had to give, saying that, yeah, I committed the crime. But even so, there was a restraining order in place. It may be set aside at a later point, which I doubt, but there was a restraining order in place. But in order for it to be legal impossibility, he'd have to be charged with attempt. He was not. He would have to think that he was committing a crime, which he didn't. And he would have to be incapable, even if he did all the things that he was trying to do of completing the crime, completing the attempt, which he was capable of, and he did. None of it makes sense. Buzzwords by a dumbass to try to make you think that he knows what he's talking about because he wants to tell Lane Meyer supporters for clicks and views so they keep watching his videos that they're right. He's not telling them actual law. He's not giving them an actual analysis. He's telling them what they want to hear. Lane Meyer supporters don't want to hear what I have to say, not because I'm wrong, but because it doesn't match with what they want. They want Ehline to tell them that, oh no, Lane Myers is going to pull this out. He always comes out. He always wins. He always finds a way. Well, I mean, except for the time where he lost the civil harassment restraining order hearing, except for the time he lost on his criminal conviction in Arizona, except for apparently the other 3 or 4, I think they were determining this would be his 5th and 6th felony, except for the other 3 or 4 felonies that he had. I mean, he wins every time except those. He wins every time except, I think, on his lawsuit in, Wisconsin? He lost that. So, I mean, he wins except for when he loses, right? It's one of those weird things that the myths that surround Lane Myers that just make absolutely no sense. They're completely not grounded in reality. The dude doesn't win. He's not a winner. He's what we like to call the opposite of a winner, aka a loser for the Lane Myers viewers who are going to watch who don't understand what I'm saying. So they're just buzzwords. Lane Myers, his best shot on appeal. If he tries to appeal First Amendment, he's going to lose. There's already another Court of Appeals case that's established that statute is not violating his First Amendment rights. He could not articulate anything that would suggest he had a legitimate reason to contact her. I mean, he's just, that First Amendment is done. His best shot on appeal is to argue that the trial court used the wrong law to find that he actually committed civil harassment. The trial court used unpublished cases that dealt with criminal harassment, which is an entirely different statute, to find that he had committed civil harassment. But the odds of the Court of Appeals overturning it are slim to none. Best case scenario is they remand it back. Remand means just okay, here's our opinion. Trial court, you need to make a new order, a new ruling that's consistent with our opinion. That's what remand means, and that's incredibly common. It's very uncommon for a trial court or for a court of appeals to reverse a trial judge. Generally speaking, they say, here's the way the analysis should work. Trial court, make a new order, a new ruling based on our analysis. That is best case scenario. And if it goes back down, considering that he was convicted, he pled guilty to subsequent harassment, that means there was harassment, and the trial court's just going to reverse engineer and make a new order that's consistent with the Court of Appeals that says, no, the injunction against harassment stays. And even if it doesn't stay, it doesn't really matter. It has zero effect because there's that permanent one from the trial, from the sentencing, or from the plea bargain and the sentencing that means that he has a permanent injunction against harassment against her on a permanent criminal injunction against harassment. So zero net effect. It won't change anything. The analysis was stupid. Ehline's stupid. I mean, do with that as you will. Thanks for watching. And I'll give, like, if Ehline wants to make an actual bet that's recorded, I will give him 10-1 odds. I will bet $1,000. If Lane Myers, if his criminal conviction is set aside, if his criminal sentencing, whatever, is set aside as a result of that appeal on the civil side, I will bet him $1,000. So he'd have to pay me $1,000 if I win. I'd pay him $10,000 if he wins. Won't happen. Even if there's no way that the civil appeal will ever set aside the criminal appeal. And that's even assuming that Lane Myers actually does the writing necessary to the brief necessary to actually get the matter in front of the Court of Appeals. So, yeah, I mean, it's not happening. It's just not happening. Like, the level of error that would have to happen in the Court of Appeals, and I mean, the state would be able to challenge the appeal to the Supreme Court. I mean, it's just not happening. It's just not happening. So many errors would have to take place. Like, judges make mistakes all the time. Yes. But so many judges at so many levels would have to make so many mistakes, and the state would have to just be like, yeah, well, fuck it. We're just going to let a perfectly valid plea bargain just go down the shitter because of some completely unrelated appeal and not challenge it and blah, blah, blah. I mean, so many people would have to just shit the bed that it's just not happening. The odds of it happening are infinitesimal. They're really low. Infinitesimally? Whatever. They're really fucking low. It's not happening. Anyway, thanks for watching. Have a great day.